We hear in the news all the time about companies who have experienced a data breach. Understanding what to do if this happens to you is critically important. Breach response requirements vary from state to state, including with regard to the type of information that's protected, the type of notice that must be given in the case of a breach, and the definition of data breach. I'll be discussing the Massachusetts requirements. Despite the variations in state law, however, the bottom line is that companies that handle personal information have to be prepared to respond promptly in the case of a breach. Under the Massachusetts regulations, the definition of personal information that has to be protected is relatively narrow. However, in comparison to many other states, the requirements for safeguarding the information are fairly stringent. Indeed, while other states may simply require the maintenance of reasonable safeguards, the Massachusetts regulations provide fairly specific detail about the administrative, technical, and physical safeguards that have to be put into place. When a data breach occurs, an entity which owns or licenses personal information of a Massachusetts resident must make 3 types of notifications: to the Massachusetts Attorney General, to the Director of Consumer Affairs and Business Regulation, and to the affected resident. The law provides detail on what each of these notices must include. However, service providers who do not own the data have different and slightly less onerous reporting requirements. Companies who believe or suspect that they may have experienced a data breach should contact counsel to determine whether a breach has occurred under the law, and if so, what steps must be taken to address it. If you are concerned about whether you've experienced a data breach, please give us a call. We'd be happy to help.